Prince Harry has lost a major legal battle against the publisher of the Daily Mail, and just hours after the ruling, he responded with some of his strongest words yet. The court dismissed the case brought by Harry and 6 other high-profile figures, but the unanswered question now is what this defeat means for his long-running fight with the British tabloid press. On July 7, 2026, the High Court in London handed down its judgment in the case against Associated Newspapers Limited, the publisher behind the Daily Mail, the Mail on Sunday, and MailOnline. The claimants included Prince Harry, Baroness Doreen Lawrence, Elizabeth Hurley, Sir Elton John, David Furnish, Sir Simon Hughes, and Sadie Frost Law. They had alleged that private information was gathered unlawfully for stories published across several years. For verified entertainment updates without the rumors, subscribe to Starline Entertainment. The case was not just another celebrity dispute with a newspaper. It was part of Harry's broader legal campaign against British tabloids, a campaign he has described in deeply personal terms for years. But this time, the court ruled against him. Mr. Justice Nicklin concluded that the claimants had not proved their pleaded allegations of unlawful information gathering. In simple terms, the court said suspicion was not enough. The claimants had to show on the balance of probabilities that specific articles or incidents were the product of unlawful conduct. That distinction is the heart of the story. The claimants argued that the publisher used methods such as private investigators, deception, phone hacking, and improper access to personal information. Associated Newspapers denied the claims. After a 46-day trial, the court looked article by article and incident by incident, rather than treating the case as a broad public inquiry into the company's past behavior. The court summary said the trial examined 57 separate articles and incidents. It also made clear that the judge did not make a general finding on whether unlawful information gathering was widespread or habitual at Associated Newspapers. Instead, the ruling focused on whether the evidence proved the individual claims brought by these 7 claimants. That is why the ruling became so consequential. It did not say the press has never behaved unlawfully in other contexts. It said this case, as pleaded and argued, was not proved. Harry's response came quickly. In a joint statement with Baroness Doreen Lawrence, he said they had gone to court seeking justice and accountability, but had received neither. The statement called the judgment a complete and obvious whitewash, and argued that the court had ignored evidence they believed remained compelling. That response shows that while the legal claim was dismissed, Harry and Lawrence do not accept the ruling as the end of the moral argument. Associated Newspapers saw it very differently. The publisher welcomed the ruling as a major vindication of its journalism and said it would seek to recover legal costs, after a trial it said had cost more than £50 million in total. That means the next stage may not be about whether Harry and the others proved their claims. It may be about money, costs, and any further legal steps. The timing also made the moment more visible. Harry was in London the same day for Invictus Games-related events. Shortly after the ruling, he appeared publicly at Chatham House. During that appearance, he did not dwell on the court defeat. He opened with a light remark about the room having air conditioning and later left the venue smiling and giving a thumbs up. That public composure stood in contrast to the force of the statement released after the judgment. To understand why this matters, it helps to place this case beside Harry's other press lawsuits. He previously won damages in a case against Mirror Group newspapers, where a judge found that some articles involved phone hacking or unlawful information gathering. He also reached a settlement with News Group newspapers, the publisher of The Sun. After that, publisher offered an apology for serious intrusion involving unlawful activities by private investigators working for The Sun. But Associated Newspapers made no admission of wrongdoing in this case and defended the claims through trial. That made the Daily Mail case different. It was one of the final major fronts in Harry's legal campaign against the tabloid press. A win would have strengthened his public argument that unlawful practices went wider than some publishers had previously acknowledged. A loss gives Associated Newspapers a powerful legal answer. The allegations in this case were not proved. Still, the ruling does not erase the broader history of the phone hacking era in Britain. It does, however, show how difficult it can be to prove old allegations in court, especially when a claimant is trying to link specific articles to specific alleged methods many years later. The judge emphasized that the court could not simply assume unlawful sourcing because information was private or because the publisher could not positively explain every route by which it was obtained. That is the legal line viewers need to keep in mind. The court did not rule on every historical question about British tabloids. It ruled on whether these claimants proved these claims against this publisher. That is why the judgment is both narrow in legal structure and huge in public impact. For Harry, the emotional stakes are obvious. His criticism of the British press is tied to decades of public scrutiny. His mother, Princess Diana's experience with media attention, his relationship with Meghan, and his own accounts of press intrusion. But courts do not decide cases on emotional stakes. They decide them on evidence, legal tests, and whether each claim is proved. For Associated Newspapers, the ruling allows the publisher to say its journalists were exonerated in this case. For the claimants, the ruling feels like a refusal to accept a pattern they believe was visible from the documents and testimony. That gap between legal proof and personal conviction is why this story is not ending quietly. The clearest confirmed status is this: Prince Harry and the other claimants lost the case. The claims were dismissed. A further consequentials hearing is scheduled for July 29th and 30th, 2026, where costs and other matters connected to the judgment are expected to be addressed. Any possible appeal steps would depend on what follows procedurally. The startline takeaway is this: Harry's public fight with the tabloid press has reached one of its sharpest setbacks, not because the subject faded, but because the court said the evidence in this case did not prove the allegations. His statement shows he strongly disagrees with that outcome. Associated Newspapers says the judgment vindicates its journalism. And the next thing to watch is whether the dispute moves into costs, appeal arguments, or a broader public debate over what courts can and cannot resolve about press accountability. For now, the lawsuit is dismissed, the reaction is public, and Prince Harry's battle with the British press has entered a new phase. Not a new trial on the facts, but a fight over what this ruling means.